And welcome back. We're heading into the first segment of our show this morning, which is the conversation with the esteemed Anthony Sylvestre. He is an attorney at law who's here this morning to discuss the overview of the crime bill. Good morning, Anthony.
Hey, good morning, Isani. Good morning, Marlene. Thank you for inviting me on the show. During the first section, I was viewing you whilst, in the waiting room, and we were discussing the issue with respect to crime, no? And so I don't know if that was deliberately done to jolt me to change my perspective. That
Well, consider it a refresher then.
Yes,
if for any reason you may have forgotten your purpose of being on the show this morning, the fact that we woke you up with that cup of coffee is a refresher.
Yes, it is. And indeed, the issue of crime, and particularly violent crimes committed with serious weapons, in particular a firearm. It's been an issue that we as a country have been grappling with for many years. Yeah. Recently, in April of this year, the legislature, the National Assembly, passed 3 amendments specifically relating to a legislation known as the Crime Control and Criminal Justice Act, the Firearms Act, and the Police Act. But for purposes of our discussion, I will concentrate primarily on the Crime Control and Criminal Justice Act. Yeah. Now, the Crime Control and Criminal Justice Act, as the name indicates, it was actually 2 pieces of legislation that actually were merged and fused together. There was firstly the Criminal Justice Act, which was passed in 1992, and then there was the Crime Control Act, which was passed in 1995. And so this issue of trying to address in particular the issue of criminal gangs. These legislations, as I understand it, they were, and in fact, actually the long title to the legislation, the long title is usually an abbreviated description of what the legislation is, and it speaks to the fact that this law was passed for better maintenance of public safety in order to discouraging membership of criminal gangs and the disruption and suppression of criminal gang activity. Now, the criminal gang activity has been with us for many years. As indicated, the Criminal Justice Act was passed way back in 1992. I recall as a young man, in the early 90s, while I was attending high school, I witnessed firsthand the actual gradual upsurge of gang activity, and I could say I'm very blessed and grateful that I was able to actually escape that being pulled into that web of criminal gang, because indeed it is an allure to many of the young men during this rites of passage. Young men are gravitated to the particular allure which this criminal gang lifestyle portrays, where there seems to be an easy access to money, to clothes, and these are things which, whilst we're actually progressing through adolescence, we gravitate towards. Yes. And so
Can I say something there? Because I think that is important. When we talk about gangs in the country, it's always important to put it in context as well.
Yes.
And we know that there are social issues that contribute towards young men joining gangs.
Yes.
And for the reasons you pointed out, in addition to camaraderie and the protection that comes with it as well,
yes.
And a lack of alternatives.
Yes.
However, the primary approach that we've taken when we see a surge of gang violence is moving towards more punitive legislation.
And brute force.
And we have seen several changes before. The Firearm Act is one. And we look at the detention rate as to what comes out of these particular amendments. Let's take the opportunity. The latest reaction to the surge in violence that we've seen, the gang-related violence that we've seen, are these particular amendments. And this is where we really see the bringing down of the hammer
Yes.
on gang-related
Yes.
activity. Let's talk about those.
Yes. If I may, before I actually speak to the specific provisions, and as you indicated, they are very, very punitive in nature, I actually would like to segue a little bit, with your permission, the fact that indeed there has been, in my view, and I don't think it's only me, you've indicated it, a loss of focus or perspective with respect to addressing criminal gang activity and the suppression of it. You would be amazed that as way back as in 1995, with the introduction of the Crime Control Act, there was provision for the establishment of what is known as a Crime Control Council. And if I may, I would just like to read to you what was the purpose of this Crime Control Council, and you see, as way back as 1995, which is 23 years ago, there was a appreciation and understanding that that to address crime, there had to be a multi-sector approach. So the Crime Control Council was established, and it was tasked with the following: with monitoring the circumstances, the crime situation in the country on a continuing basis, planning, developing, and coordinating comprehensive crime prevention programs and strategies, promoting employability and job placement of unemployed youth, liaising with a broad spectrum of community-based and social services organizations to develop a coordinated team approach to reducing gang violence or the effects of substance abuse or other criminal activities, soliciting contributions and donations from business sector and other donor agencies to find constructive program for reducing crime. So that as way back as 1995, there was a realization, appreciation that there had to be a multi-sector approach with respect to crime. As you indicated, Marlene, however, and it could be understood why, perhaps maybe that perspective has been lost. There has been an extreme upsurge in crime, in particular violent crimes. And murder is at an we keep saying this every year, that murder is an all-time high, and it almost becomes quite passé. And in a sense, we've become so numb and desensitized that it perhaps may not have any impact on us. But
it has become commonplace.
It has become too commonplace. But the fact of the matter is that when this occurs, when there is this upsurge in crime, legislatures, they must respond. And the whole purpose of legislatures is that they pass laws to regulate the way crime or whatever situation or problem that arises. And instinctivly, it is for there to be a very, very, very heavy-handed approach. And so,
which the public calls for
which
as
the
well.
public calls for, and which certainly I would agree is necessary. And so these recent legislations, amendment to the Crime Control and Criminal Justice Act, they indeed are very, very they mete out very, very severe penalties. And if I may, I would just like to go through several of them. Now, as indicated, this issue, and just to get back to what you've been saying, you know, we have been trying to tinker with and address this crime issue for many, many years. I mean, just for example, the Crime Control and Criminal Justice Act has had amendments in 2003, in 2008, 2010, 2012, 2014, 2016, and now again in 2018. And these are all attempts to try to address the issue of crime, whether with respect to addressing criminal gang activity, restriction of bail, making it more difficult for persons who are accused of certain crimes from obtaining bail. So these are all measures which have been employed in an attempt to try to minimize, to stabilize the whole criminal gang activity.
Can I just ask a question there? We've seen you very often within the court in looking at when these particular amendments are made. Is there a shift in terms of what we are able to charge these criminals with? Is that perhaps it? Because we know one thing, our laws are antiquated. Many have spoken about a complete revamping of our legislations. And so it seems that where society is growing, we're just trying to make amendments to have our laws keep up. If I look at one example, the firearm, the amendment of the Firearms Act, when it spoke of anything related to a firearm, would be immediate remand.
Yes.
And then you apply for bail subsequently if you can. Are these perhaps moves that have been helpful in being able to get the criminals held accountable for what they do?
Well, in response to the issue with the Firearms Amendment Act, so there were constitutional challenges in the courts with respect to those amendments, which had made provision for every single individual who was above the age of criminal culpability. So in other words, once you're over age of 13, the law deems that you can be convicted of a crime. Every single such persons were caught into a web, and they were deemed to be in possession of a firearm or an ammunition when it was found on a premises. And quite interestingly,
it goes back to the famous Allison Major case.
Yes, it goes exactly. And I think if my memory serves me right, there was a concession in that case by the government that it was passed in an attempt to try to arrest the crime situation, and the government felt at the point when this case was brought and determined, it should have been in like 2016, that they were of the view, okay, that the crime situation was at that point arrested, it was stabilized, and so what followed was that that specific amendment, which was admittedly unconstitutional, it went too far, that was repealed, and so another provision was actually introduced. Now, with respect to what you had asked, Marlene, whether
the effectiveness,
I can't speak to whether that was in fact effective or not, but the government's position that it was, and that in terms of shifting burden, that is what that legislation did. What it did is that it shifted a burden on a citizen to establish that, well, you know, whilst I live here, maybe I have no knowledge, I have no control over the premises, but I live here. It nonetheless placed a burden on that individual to show, listen, they in fact didn't have any knowledge. And in doing that, what was argued in that case is that it went too far, that it violated a very simple or basic principle in our Constitution, that you're presumed to be innocent. The government's position, and that I understand as well, is that, look, we were faced with these very, very difficult and trying situations. We had to pass laws to be able to address and arrest the situation. What would you have us do? And so those competing perspectives.
Isn't it sweeping, though, in terms of its scope? The fact that, for instance, if we were to sort of look closely at what happened in the case of Mr. Major, which was one of the matters that you represented. This individual, as far as we know, did not live at the premises. He was only visiting based on the circumstances there. And he was corralled along with the rest of them when a firearm was found at the residence.
Well, because the provision at the time deemed not only persons who live there, but ordinarily reside there, so that it was in a visiting relationship with someone at the premises. So, you know,
once you're there,
he would. Well, he was not there, but he probably. Well, I don't want to go into the details, but there would have been a visiting relationship, and so he would have been caught under the provision as being ordinary resident there. Now, with respect to these specific amendment, there is a very curious set of provisions which seem to be going down the same road. Now,
before we move on to that, because I wanted to build a connection here, talking about specifically the firearms, and I know it's been called sweeping. We've talked about people who we get very concerned when we see grandmothers, pregnant women, people who we feel may not be involved in any illicit activity being carried off to the police station as a result of a gun being found. But now we see where the mentality has shifted as well. In fact, the ammunition and the weapons are being found in abandoned lots.
Yes.
So one would say it's not necessarily that it has stopped the issue, it just allowed for a change in tactics.
Yes, yes. Yeah. Well, certainly, at some point in time, and I think that was the intent, the state felt, listen, these criminals, they must at some point feel some empathy, and they must feel some pain for the fact that their loved one is being carried off to prison, so that they may then begin to either confess, admit to the crime. That of course,
that reason that doesn't hit me as realistic.
That didn't work, and so as you indicated, Marlene, what happened was that there was a change, a diversion in the tactic in terms of how and where these weapons would be placed, and then they would be housed. For my part, I've always, however, found it very, very intriguing that I don't know where these unemployed, poor individuals, where they get these weapons from, and I'm happy to say that in these amendment, the legislatures for the first time seem to have appreciated the fact that, well, you must have people who,
there is a business.
Yes, that you have people who are wealthy and who have monies who are financing these.
So let's move into the amendment.
Yes. Okay. So there is a provision which provides that gang membership is a criminal offense, and on summary conviction, the person is liable for 10 years, and on a subsequent conviction up to 25 years. And the gang leader, they of course they suffer a more and as they ought to, a more punitive sanction. They, on first conviction, they are liable for conviction for 25 years.
So it's always been illegal to be a member of a gang.
Yes.
This is simply having stronger measures in place.
Yes.
And the separation of the charges for a gang leader as well.
Yes.
With more rigid penalties.
Yes.
My question is, as an attorney, how does one prove who's the gang leader and who's the gang member?
Well, the provision has, in a sense, made or will make it a little more easier for the prosecution and the police in terms of establishing these things, much to the I'm fair to the chagrin and to the of ordinary citizens. For instance, there is a offense known as harboring. Harboring is defined, and it has a very, very strange definition, and it includes a person. It includes a person providing harbor for an individual.
So if I hide someone in my house.
Yes. And in addition to that, whether that person either tacitly or expressly, that person as well assists that individual. Now,
what does that mean?
Well, that's just it, because tacit assistance.
I was just about to say.
Yes.
Tacit is not as direct and as open as we would say. It's sort of, well, I never really know. I just may help. I just may try, as opposed to knowingly doing something in the assistance of that individual. So does that mean if I lend them my car or give them money, then I am also assisting? Well, that could very well be. So then what happens in a case then where, if you understand how these elements function, a lot of people are brothers and cousins and stuff. So when you have them around, you won't deny your brother, your cousin, or, of things that you would enjoy. So in that case, then are you tacitly empowering, if I may, these individuals? Well, that is a concern, because the way the legislation is framed, as indicated, it says giving refuge or shelter to a person and encouraging or supporting this person tacitly or explicitly. And so, as you indicated, a mother, for instance, let's say they have a house, and they allow you to stay in that house, and they fully well know what's going on there. So you are providing a refuge to that person, a shelter, and you, in some respect, would be said to be tacitly encouraging that person. So you're guilty of that offense, and that offense is a 5-year penalty. So then,
Anthony, we have a bit of clarification here, because I think one of the things that isn't very clear and is becoming very obvious to me here, Does it matter whether or not this person is someone that the police is looking for? Is it me harboring a criminal when the police are looking for them? Or is it the everyday housing that I provide to my child who is, in fact, a member of a gang?
Well, let me read to you what's the definition of
Okay.
harboring. You see, because that is just it. It perhaps may not have been the intent, but the way it is defined, it may include such. It says harboring means giving refuge or shelter to another person and encouraging or supporting, whether tacitly or explicitly, that person in committing any gang-related activity. And the concern with respect to tacit support or encouragement, because explicit encouragement is one thing. You give money or to give a gun and stuff like that. But tacit, as you indicated, is someone may have a son, make it stay that they have a house, make it stay there. They know what may be going on there, but come on.
Do you put out your son?
Do you go to the police and tell them, I want to have him be removed from the house?
Yeah.
You see,
or I want to report my son for having done this or that or the other.
Exactly. So that raises a concern, because I'm wondering whether the intent is to try to jolt the general citizenry from and dissuade them from that, to have them be more proactive and say, listen, okay, I know my relative or my brother or my boyfriend is involved with this, so I will now be more proactive, and I may not want to do anything, have any kind of association with them. That could very well be maybe the intent, but in a very small society like ours, I'm not quite sure how, to what extent that may be very realistic.
Yeah. Well, I mean, let's be honest. These laws weren't concocted out of the imagination of the people involved. I would imagine there are perhaps instances where family members, community members, house members who live in the very same household are very well aware of what's taking place. Did the laws previously provide for any type of charges for someone who shelters someone involved in criminal activity?
No. The law didn't do that, and what the law did is that the amendment, what it does, it repealed the previous provisions that dealt with the whole issue of gang suppression, and so there are there are many more provisions which addresses the possible types of situation where criminal activity, gang activity may be condoned or may be encouraged or be supported. So I get that, and I think everybody gets that and would appreciate that, and certainly would understand the need for such legislation. Of course, the concern always is, as the courts always do, is that how far does the legislative aim, objective, is pursued?
Let me ask you a question, and I'll try to be as realistic and as pragmatic in my view here. You have a neighborhood, the Mayflower Street area, where it's a dense concentration of people living together in one small community. You have the elderly, you have the middle-aged, you have young kids growing up in one very dense environment. And it's also known for the gang activity that comes out of the Mayflower area.
Well, you have a law.
Doesn't that then put everybody in the same bag, so to speak?
You have a provision which I don't think it's, I don't think the law was specifically made to address that, but there is a provision, for instance, which speaks of hindering and preventing the investigation or prosecution of a gang member by inciting or inducing another to commit offense or violence. So the police, they go into an area and they may want to look for a gang member, and they neighborhood.
Well, we saw the video.
Yes, that is a very serious offense, and the person is liable, or persons are liable to 20 years on the conviction and indictment. So the provisions, they seem to be addressing, quite a lot of the scenarios that we see. But as you indicated, Isane, about the type of environment and the type of neighborhood is such. Like
that creates, you have two sides of a
Is it
coin
to allow
there.
for a threat of a charge? Because we don't always, and no, I'm serious. I think
No.
we speak of people being gang leaders. We recognize, and even in police reports, often we hear police officers saying this person is known to be related to a gang, which is an offense. But we don't always see these charges brought to the courts. So I'm wondering if perhaps these amendments are not being used as a potential threat to get people to work along with the police, because we don't always see it moving to the court itself.
You articulated better, and I was trying to say that a while ago, but you succinctly put it. Yes, it does seem as though that is the intent, just as was the intent with the Firearms Act, to get people to work with the authorities, for them to be able to speak to and provide evidence and assist the police in their investigating process and try to get more convictions.
I look at various scenarios, and you'll forgive me if at this point my mind is racing with all these thoughts. So if we take the same Ghost Town example, the same Mayflower Street area, you have people who have grown up in that community. You have people who have passed through the entire gang scenario and have reformed to some extent or to a great degree their lives. Maybe they've had dead brothers and so forth that have, they come to a realization, you know what, this is not for me. But they've moved out of Ghost Town, but all the tattoos and everything are still on them. People are still being charged for displaying gang insignia by way of tattoos and what have you, correct?
Yes. It's on the law book. I'm not quite sure if they're charged as much, you know?
Yeah.
We haven't reported very many.
Yeah.
But they are, in the last interview that I did with the Attorney General, I believe he mentioned that yes, indeed, it is on the book and it is still being carried out, right? But you would have to prove then that you are either reformed or you have moved completely away from either that influence or that environment, notwithstanding the tattoos and what have you on your body. Yes. But I'm saying, if you look at that particular scenario, this person comes from that neighborhood. This person may have chosen to, you know, move away from it and whatever, but it's almost as if though you're still being either subjected to or singled out based on all those components, so to speak. Doesn't that then become discriminatory? If the police were to pick you up and say, well, you know what, we'll charge you for your, in this case, an appearance because you have the tattoos and they're visibly being displayed and they know that you come from a certain neighborhood. Doesn't that then kind of become discriminatory?
Well, discrimination in the context of the Constitution, or what the Constitution prohibits, is when persons are treated differently based on their race, their religion, or as well maybe where their place of origin. The thing is that with respect to all constitutional rights, there are limitations, there are restrictions. The Constitution allows for the legislatures to restrict those rights. And there's like a three-pronged test that the courts look at when trying to determine whether that law which was passed, it went too far or it is acceptable. They say, okay, look, all right, what is the purpose of the law? It's the purpose of the law to address a crime situation. Okay, good, so that's fine. They look at then what is the means used. Okay, to what extent are they trying to address crime? It makes it a criminal offense for you to have a tattoo or a certain insignia. So you look at all of those. The court will look at all of those things, and as you say, for instance, if a person were to provide and show, listen, these tattoos have been here for 10 years or stuff like that. I do believe that I don't think such a person could seriously be convicted. I think that such a law...
But the law actually says that they're not guilty if they prove that they got the insignia before the enactment of the law, or if they have not taken part in any activities since the law was introduced.
Yes.
So
and to the point I was going to make is that the law wouldn't necessarily take such matters into consideration. You were discussing earlier, and I just found the provision about concealing. It's a very interesting provision.
This is going back to what was in place before harboring, right?
No, this is one of the new provisions.
Okay, go ahead.
It says a person who conceals another person who he knows We ought to know is a gang member. I don't know how you ought to know.
To know.
Ought to know is a gang member is wanted by any law enforcement authority. He commits an offense if he conceals that person. And now this is the tricky part and the troubling part. It says you conceal a person if you know or ought to know that a person is wanted, and in response to an inquiry from a law enforcement authority, you do not reveal the whereabouts of this person to the inquirer. Now that is, I think, extremely dangerous, because if you, for instance, is trying to know where some reputed gang member is, and they go to you and say, Sana, we know you know where Mr. X is, and you refuse to give the whereabouts of Mr. X, you can be charged for concealing. Now, I find that to be a little bit too widespread.
Isn't that an obstruction of justice as well?
No, but you see, it also puts you in dangers.
Does not put
the
in
person
people though, because
I'm so glad you brought up that point. We're going to continue. We're going to continue because we also have to talk witness protection as well. This is going to come up after the break. We're going to take a quick break and be back in a few. Stay tuned.